Well, hello everybody, welcome back. James Pfeiffer with ACCU, and today we're going to be talking about mechanics liens. So a little bit why this particular story is important to me. Back in 2015, I had just taken the role of president for my company, and within days of taking over as president, I received notification that one of my properties had been liened. And there was a lot that I didn't understand about how liens worked, and it could have cost me the company. So as you can imagine, this is a topic I'm pretty passionate about. I gave an education on this to my staff and thought, you know what, this is something the broader community should probably have a discussion about. So if I don't get this one completely right, feel free to correct me in the comments or come on the show. Let's have a conversation. So let's talk a little bit about what mechanics liens are, at least from my understanding. So in the scenario that happened to me back in 2015, there was a company that was doing restoration. They got hired for a roof job, and essentially what went down is they misnegotiated the roof claim, and it left them without enough money to pay the subcontractor. So in this scenario, the GC was paid for the work that was completed, but the subcontractor was not, and therefore that's where the liens came from. So if you've ever wondered what happens when a contractor doesn't get paid for the work in the community that you're managing, then they might have the right to file a mechanics lien. So today we're going to break down what that means, what the process looks like, and how communities can respond. All right, so what is a mechanics lien? A mechanics lien is a legal claim filed by a contractor, subcontractor, or a supplier who has provided labor or materials for a project but has not been paid. It attaches to the property, not just the person who signed the contract. So in a community association, that can mean the lien is placed against the common property, or in some case, each owner's interest. From my experience so far, the contractors normally do not place a lien on the common elements. They choose to place it on the owner's units. And I think the reason is largely strategical, right? Primarily because if a lien is placed on the common elements, not everybody is notified, but when it goes on each owner's unit, you got a problem, right? And they know that. So in my experience, I think that is primarily why they go out and they lien each unit owner in the community. Processes for filing a lien: the contractors must follow strict statutory steps, and these can vary state by state, but here's the general breakdown, right? First, you got the preliminary notice. Many states require the contractor to supply the sender with a notice of intent, or an intent to file a lien, or pre-lien notice, or whatever, to the property owner and the association's board within a set number of days after starting the work or delivering the materials. Number two, deadline to file. The lien itself must usually be recorded with the county clerk or recorder within a specific time frame. And that can range, it's 4 months, 6 months, 60 days, 120 days. It just depends on where you are. And missing that deadline means losing the rights to that lien. And why is that important? Managers, contractors who have not done a good job will sometimes threaten filing a lien on your community. It's really important that you go look at what legally they have the right to do, because if they're past their lien rights, then I wouldn't take that as a threat. But also understand that once a contractor's lien rights have expired, that doesn't mean that they can't bring a civil case against the association. So just because lien rights are over doesn't mean it's over. So next, number three, lien content. The document must include the name of the claimant, contractor, subcontractor, supplier, right? We went over that. Description of the labor and materials provided, a proper description of the legal address and or the parcel number, and the amount claimed. Next, number four, notice of filing. After filing, the contractor must usually serve a copy of the lien to the association. What happens after the lien is filed? Cloud on title. The lien attaches to the property record. This can delay refinancing sales or loans involving the property. And this is where problems will really occur for you community managers out there, the board members, and of course the homeowners who are trying to sell the property. Payment pressure. This one's important. The association may feel forced to resolve the debt, even if it's disputed, because the lien creates a legal and financial uncertainty. The foreclosure action: if unpaid, the contractor may take the next step of filing a lawsuit to foreclose on that lien. And if successful, the court could force a sale of the property to satisfy that debt. There are options for a community to respond, one of them being review the claim, confirm if the work was authorized and if the amount is accurate. Sometimes liens, they're filed improperly or they're exaggerated. Next, negotiate and settle. Payment negotiations or mediation can resolve disputes before things escalate. Defenses, if the lien was filed incorrectly or the contractor missed the deadlines, the association can in fact challenge the lien in court. Number 4, bonding around the lien. This is a powerful tool. The association can purchase a surety bond equal to the lien amount plus the buffer required by your state law. The bond replaces the property as security, freeing the property title from that lien. So in the event that you have owners that are looking to sell and there's liens on the home and you're looking for a way to get the lien off that property, a surety bond can certainly be an ace in your pocket. The contractor must then pursue the claim against the bond, not the community's property. Some other important details are owner assessments. If the lien is valid, owners may see special assessments or increased dues to cover the payment. In the event of subcontractor liens, even if the association paid the general contractor, unpaid subs or suppliers may still file liens. This makes it critical to require lien waivers from contractors before issuing payment. If you are not doing this already, stop what you're doing right now and create your lien waiver. And do not make any payments to contractors without a lien waiver. And here at ACCU, we do a couple of steps. We have partial lien waivers. So if a contractor is working through a project and they need payments to be able to complete it, for each time they get to a place where they can submit payment, we are requiring a partial lien waiver for what they've done. And then at the very end of the job, it's a full lien waiver. If you don't have that already, again, stop what you're doing and start doing that right now. There's state variations. Every state has unique deadlines and notice requirements. And boards should consult their association's attorney as soon as a lien is threatened. Mechanics liens are serious, but they don't have to be devastating. And I know they're new and they may not be familiar and it can just be a shock. So understand the process, require lien waivers, understand your bond options to bond around the lien, and communities can protect themselves. When in doubt, always consult your association's attorney. These issues can be complex. And as I talked about, one kind of broad overview of how liens can happen or operate inside of a community, there's a bunch of different ways that these can come at you. So just be on the lookout, be prepared, be proactive with those lien waivers, and then make sure that you are always consulting your association attorney, because this is not legal advice. I'm not an association lawyer. And make sure you always go to your community association's lawyer before you follow my advice. So if you have any questions about this, my name is James Pfeiffer. I'm with ACCU. I'm always a resource to you. And if you ever want to come on my channel and have a conversation about this topic, you are more than invited. You can reach me directly at 303-733-1121. And as always, until next time, I look forward to bringing you additional educational content. All right, see you then. Take care.